Jerry Buting delivered the first part of his defense closing, which was supposed to not duplicate each other's topics, but I knew they would. The judge also refused to set a time limit on closing arguments, instead cautioning the attorneys that he had no intent to throw the lawyers a lifeline if their closings rambled too long and the jury became disinterested in their arguments. This was meant, of course, to put a practical time limit on their closings, that which jurors would be able to absorb. As predicted, Buting's closing was sharp, bordering on mean-spirited when commenting on police behavior, which he characterized as not just sloppy, but criminal, with allegations of planted evidence. He challenged the scientific evidence presented, speculated how certain evidence may have gotten places, asked the jury to, quote, think over the break, close quote, why the court dismissed the false imprisonment charge, insulted the victim's memory by wondering if her own lifestyle may have contributed to her murder, etc. It was hard to listen to. Then, Buting dropped a huge bombshell when he asked the jury if perhaps Bobby Dassey may have killed Teresa. I immediately objected. I was furious because the court had ruled before trial there was no evidence to support a theory of a third-party liability for several people, including Bobby Dassey. I honestly thought that Buting's comment was an intentional attempt to create a mistrial. Sometimes when all the evidence has gone so badly for your client, a purposeful comment which leads to a mistrial grants your client another new shot at a better presentation of the evidence. How could Buting, a supposedly skilled trial lawyer, just forget that the defense was precluded from introducing Bobby Dassey as the real killer? So, in my opinion, it was deliberate. I objected. I asked the court to be heard outside the presence of the jury, and the judge said that he'd take it up after Buting finished his rambling closing, meant to be just the first half of the defense argument. After Buting eventually finished his argument, I asked the court to inquire directly from Attorney Buting whether his comments were intentional and whether he was searching for a mistrial. Buting denied that his comments were anything more than a comment on the fact police didn't know who killed Teresa, and he just got, quote, carried away in naming Bobby as the possible killer. The court reread his order excluding third-party liability and noted the prohibition was from entering any evidence or testimony about any other possible killers, including Bobby. The court noted, however, that his order did not specifically exclude arguments to the jury about possible killers. In pointing out to the court the absurdity of that logic, that you can't ask any questions of witnesses that suggest Bobby might be the killer, but you can then just come out in argument, presumably based on no evidence, since it wouldn't be allowed, and outright name Bobby as the real killer? The judge recognized the conflict, but he refused to sanction Buting or to grant the state an instruction to the jury. What a strange and disturbing comment. Because Buting's argument went so long, and the jury appeared tired and didn't look like they could pay attention to Strang's second half of the closing, the judge announced he was going to quit for the day and make the jury return the next day to hear Strang's closing and the state's rebuttal argument. In chambers, I was livid, at one point engaging in a heated exchange with the judge, reminding him of his promise not to throw the attorneys a lifeline, and that if the jury was unable to follow Strang's argument, it was due to Buting's disregard for time. It wasn't the state's fault. Why should the defense be rewarded with another day to give a second closing argument? Again, without any time limits. The judge told me in no uncertain terms that his concern was for the jury, not for the attorneys. If they were too tired to hear anymore, there was nothing that he was going to do to force the issue. Just another ruling that benefited the defense. That night, I wrote my rebuttal. The judge did excuse the two jurors the parties agreed as additional preemptory challenges, and would not make them come back the next day to hear Strang's closing or the state's rebuttal. I was absolutely spent when trying to write my rebuttal. I didn't get very far that night. As I expected to be done that day, I was emotionally exhausted, so didn't have much left and went to bed. I woke up at 2:11 a.m. and wrote my rebuttal at the kitchen table. This was going to make for a long day. I knew the case would go to the jury the next day. The end was in sight. But I was concerned about the defense having another full opportunity to give yet another closing argument. March 15. This Thursday started with Strang giving his closing argument. It was only about an hour and a half. His tone was very soft, yet his points were not subtle. He basically asked the jury to consider Avery's 1985 wrongful conviction and set things right by finding him not guilty.
You unfortunately are not going to be able to solve a murder here. And I say that for this reason. If Steven Avery did it, if he's the guy who murdered Teresa Halbach, then in a sense, you're not going to solve that. They already think that. This is the person they think all the evidence points to. It's the person they've identified as doing it. You can agree or disagree with that theory of prosecution. But fundamentally, you and I aren't solving a murder, because if Steven Avery didn't do it, we can't tell you who did. Jerry Buting, Jerome Buting in court, is not going to tell you. It doesn't mean to tell you that, for instance, Bobby Dassey murdered Teresa Halbach. We don't mean to tell you that someone else murdered Teresa Halbach. It's really kind of the point. So we don't have a police department. You don't have a police department. We're not going to be able to solve the murder if Steven Avery did not do it. So, you can agree with the state, you can agree with the defense, but at some level, you're not solving the murder, much as it's natural for all of us to want to do that. A second thing I think you're not going to be able to do, I'm quite certain you're not going to be able to do, is bring Teresa Halbach back through that door, or better yet, back through the door of her mom's house. We are not going to be able to do that. Convicting a guilty guy, convicting the person who killed her, wouldn't do it. Convicting someone who didn't kill her certainly won't do it. The life that was before October 31, 2005 never will be lost. It's etched in Mom's heart. It's etched in her brothers and her sisters' minds, in their memories, in the people they are. That life is not lost. The life that could have been, going forward, beginning November 1, 2005, is forever lost.
I received a hug from Karen Halbach before delivering my rebuttal, as she whispered that Teresa would be with me when I was up there. My team had urged me to be passionate and directly address the defense's lack of evidence to support their theories. I had intended on being far more animated, which was a tone change that I had planned from the development of the very beginning of my closing. I warned the jury that rebuttal arguments are a different part of the case. They're necessarily more pointed, and I intended to be blunt about what I felt about what we had just heard. I used simple black and white slides, again in a PowerPoint, which Buting had disparaged as some, quote, slick slides. I asked questions on each point that I thought I had to make. I came out from the very first statement warning them that it was also likely improper for Strang to suggest the jury consider the '85 conviction as any reason to acquit him here. Sympathy, even for a murderer, has no place in jury's deliberation. I made several references to the defense attempts to fool the jury, that some arguments were absurd. They owed apologies to the police that were accused of misconduct without a shred of evidence, and how such accusations affected these professional cops. I pointedly noted my disdain for insulting the Halbach family by suggesting Teresa had any impact in her death due to her lifestyle, which included who she lived with, that she had gone to a party 2 days before, and some other veiled accusations. I reminded the jury about the ordeal the Halbach family has been through, that Mr. Buting should be ashamed for his comments. Victims, especially those that can't speak for themselves in court, are entitled to dignity and respect. His antics throughout this entire trial showed a lack of class. Attorneys can vigorously defend their clients without accusing cops of misconduct or without victim blaming. Mr. Buting chose to do both. I ended the rebuttal going back to the facts. What evidence was found where, and what it all meant. It all pointed to one person responsible for Teresa's death. The jury had a duty to return verdicts of guilty.
There's 3 charges that you're going to need to consider in this case. Homicide, first-degree intentional homicide, mutilation of a corpse, and the felon in possession, and it's the state's obligation to prove to you several things with those. They're called elements, but what we really have to prove is what and when and how, and finally who. What is clear? That a homicide and a mutilation occurred when? It's the 31st of October, sometime after 2:45 p.m., when Ms. Halbach makes contact at the Avery salvage property. How? The doctors and the trace metals and other experts tell you by gunshot. And so when it comes down to the role of the jury, when it comes down to you as the trier of fact, searching for the truth, not speculating, not searching for doubt, but searching for the truth, it's that last answer. It's the who that you have to decide. And you've got to decide whether or not the state has satisfied you beyond a reasonable doubt who killed Teresa Halbach. Again, based upon the facts, based upon the evidence, not based upon speculation. I told you when I first stood up before you this morning that there was no question at least from the state's perspective, who was responsible. And despite having been here for 5 weeks, I'm hopeful at this time that you're able to agree with the state of Wisconsin that all of the evidence points to only one person. All the circumstantial evidence, all the scientific evidence, all the direct evidence points to one individual. The law enforcement officers have done their duty. All of the citizen searchers and the citizens that helped have done theirs. Prosecution team, I believe, has set forth a very methodical, very compelling case. And so we're finally asking you, the citizens, the jurors in this case, the citizens of Manitowoc County, to return verdicts of guilty, as it's your duty to do so. That's all I have, Judge. Thank you.
I was pleased to have gotten several compliments on my rebuttal, as it was not just the message, but it was the tone that was required at the time. The jury got the case about 1 p.m. They deliberated until 5:30 before asking to be excused for the evening. The judge allowed them to come back the next morning. Now, however, they were sequestered. They were being kept at a local hotel. Our Calumet County judge, Judge Poppy, would never have allowed such a short deliberation session on the first day of the jury deliberation. Very little good happens giving the jury more time. The impact of powerful closings lose their luster as also time wears on. But with nothing to object to, the 12 remaining jurors were sent back to their hotel. The 13th juror, the lone remaining alternate, was separately sequestered just in case. Well, just in case happened that night.
This is John Lee with an update on the Steven Avery homicide trial from outside the Calumet County Courthouse. The jury got the case about 1 p.m. this afternoon, and Steven Avery's fate is now in the hands of 7 men and 5 women from Manitowoc County. They will begin deliberations right after they have lunch, and they will be considering 3 charges: first-degree intentional homicide, mutilation of a corpse, and felon in possession of a firearm. Avery obviously faces life imprisonment plus several years on those charges. The jury is deliberating at the courthouse. They will be sequestered for the duration of their talks. 1 juror has been held out and will be sequestered separately in case she is needed as an alternate. Coincidentally, the deliberations begin 1 week before what would have been Teresa Halbach's 27th birthday. Stay tuned to postcrescent.com, wisinfo.com, or your local Gannett, Wisconsin newspaper for updates during jury deliberations from Chilton, Wisconsin.
The band member, who the state wasn't thrilled with anyway, got a call that his stepdaughter was in a serious car crash, and due to pressure from his wife about what meant more to him, his family, or the jury trial, he told the judge that he could not devote his attention to further deliberations and he wanted to be excused. After holding a late-night conference call with the attorneys, including assurances that the attorneys would not be requesting a mistrial the next day, the preferred procedure was the insertion of the sequestered alternate with instructions that the jury begin their deliberations anew. Although it was a setback and things could still go wrong with the alternate juror, we really didn't appreciate what legal challenge was in store for us the next day. The band member, the distraught juror, was discharged. March 16th. Upon arrival at the judge's chambers, which I was told the night before would be a quick colloquy with Avery about the process to insert the alternate juror, we first learned the significance of state versus layman. It requires 3 options for the judge to present to the defendant. Number 1, the defendant can stipulate to 11 jurors. Number 2, the defendant can stipulate to the insertion of the alternate. Or number 3, a mistrial. All Avery had to do was to say no to the first 2 options, and he would automatically be granted a mistrial. We'd be forced to start all over again. Obviously, if I had known this the night before, I would not have agreed to the discharge of the distraught band member juror. But Avery agreed to the alternate, which he said was on the advice of his lawyers, and the new juror was inserted. The 11 other jurors promised to start deliberations over. Yesterday's deliberations were for naught. The very tense day of deliberations ended without a verdict.
This is John Lee for postcrescent.com and Gannett, Wisconsin newspapers with an update from day 30 of the Steven Avery trial. The first month of Avery's trial is ending today with jury deliberations beginning again from square one. Judge Patrick Willis said in open court this morning that he has excused a male juror for an unforeseen family emergency. That juror has been replaced with the female alternate, and deliberations again began at about 10:21 a.m.
One of your members has been excused from jury deliberations in this case because of an unforeseen family emergency. Although excusing a juror during deliberations rarely occurs, it is sometimes necessary. The court has brought back the last alternate juror excused to participate in the deliberations in this case. The law requires that during deliberations, 12 people must have the opportunity to review the evidence in light of each juror's perception, memory, and reaction. It is important that the jury reach its consensus through deliberations which are the common experience of all 12 jurors. Each of the 12 must have the opportunity to persuade the other members of the jury and to be persuaded by them. If you have formed any views about the evidence up until now, you must set those views aside and start over. To assure that these requirements are followed in this case, you are instructed that you must commence your deliberations anew. That means that you should begin by electing a foreperson and then proceed to evaluate all the evidence as though you are just beginning to deliberate.
We'll be here throughout the trial with updates on video, on the web, and in print for Gannett, Wisconsin newspapers.
March 17th. Another full day of deliberations. The jury once again goes through the deliberations without a verdict. The impact on the victim's family, all the lawyers, the investigators, everybody is obvious. We all go home very concerned.
This is John Lee for Gannett, Wisconsin newspapers with an update on the Steven Avery homicide trial. The jury deliberated about 8 hours today before ending, just before 6:30 tonight. They will be coming back for more deliberations Saturday at 8:30 in the morning. As you know, the jury started deliberating over again today after the alternate was brought onto the panel after a man was excused for a family emergency. We will be here through the weekend until there's a verdict. Click on postcrescent.com, wisinfo.com, or your local Gannett, Wisconsin newspaper for updates on the web and on video throughout the weekend.
March 18th, Sunday. The jury resumes deliberations, and each hour that goes by, concerns grow deeper. Conflicting reports are presented on whether dinner will be brought in and whether we'll go to yet another day of deliberations. At 4:35 p.m., the judge hears the jury has reached a verdict. Both families are summoned to the court. Security is put into place. The moment before a jury walks into a packed yet solemn courtroom is perhaps the most tense moment in a high-stakes trial. The Halbach family arrives. My wife and sister-in-law get there. The media is intense. My staff is all there. The jury walks in with little reaction or emotion. Count 1. First-degree homicide, guilty. Count 2, mutilation of a corpse, not guilty. Count 3, possession of a firearm by a felon, guilty. The judge enters judgments on the verdicts and revokes his bail. The defense promises in court to file motions challenging the verdicts. I met with the Halbach family. I reminded them that the Avery family has also suffered a loss today and to please remember them in their prayers. A priest joined the family, and I invited a prayer for Teresa, but also for the Avery family. The 50-plus family members and friends provided a heartfelt round of applause for me and the rest of the prosecution team. an embrace from Karen, the boys, and congratulations all around. I gave a brief press conference. I called into WTMJ radio and talked to host and previous prosecutor Jeff Wagner about the verdict. And we all went to celebrate the results at the Outpost Bar and Grill close to the Halbach family home. My entire staff, most of the Halbach family, my family, lots of cops, and well-wishers all joined us. I'm relieved and pleased with the results. The news the next day had already been very positive, both for the entire prosecution effort and for me personally.
We as a family know we're not alone. These things happen to a lot of people, unfortunately. And Katie and Kelly, they're on their own way to good lives. I mean, they're got a good start. I think they're just learning from my parents, my mom especially. And they're learning from Teresa how to live their lives, and I think they're going to be all right. I was thinking about what I was going to hear. I was pretty confident I knew what I was going to hear, and I heard that, and I started getting a little numb. And then I heard not guilty on the second count, and then I was like, wait, what did I hear in the first one? Because I was sure, but just got a little uncertain. But I'm thankful it's over.
March 19th. I take Monday off to spend time with my wife, to go to a movie, and to go out to lunch. Things are nowhere near back to normal, but the sense of satisfaction for all the hours of preparation and presentation is rewarding. It's too early to comment on the long-term effect this trial may have on me, personally or professionally. But I have no doubts that I gave Teresa every ounce of energy and dedication in trying to hold her murderer accountable. So for now, that has to be enough.
This court, through the past 18 months, has also heard that despite the high quality and professional investigation that was performed, that law enforcement officers have been subjected to both professional and personal attack throughout, including allegations of criminal wrongdoing themselves. In fact, Judge, the entire community, that is Northeast Wisconsin, has been required to endure a year and a half of a combination of very sad news, a combination of witnessing what I'll characterize as legal gamesmanship and one version or another of the term poor Steven Avery. Well, today, Judge, is the day that the Halbach family and law enforcement and the entire community has waited for. It's the day when justice will rain down upon this cold-blooded killer. When this community, through this court and through this judge, tells Steven Avery that your evil deeds will be punished, that you'll be held accountable for your cowardly, for your senseless acts, the state then believes, and only then, justice is going to be served.
However, while the motivation cannot be known with certainty, the circumstantial and scientific evidence was strong that the defendant's actions in killing Teresa Halbach were premeditated. Your attorney has argued eloquently that the court should make you eligible for release at some point in the future. But from what I see, nothing in your life suggests that society would ever be safe from your behavior. One of the things that strikes me the most is that as you've grown older, your crimes have increased in severity. This crime was committed at a time when you were 43 years old. Given the trend of your crimes, society has a legitimate right to be concerned that there is a serious risk you would reoffend and commit serious offenses if you ever permitted to be released from prison. The moral need for punishment as a result of the gruesome murder in this case, coupled with the danger that the court believes you pose to society based on your prior history and the premeditated and senseless nature of the homicide in this case, compels the court to conclude that you should not be free again. For the foregoing reasons, on the first-degree intentional homicide charge, the court sentences you to life in prison and determines that you will not be eligible for release to extended supervision. In terms of assessing your danger to society, the evidence forces me to conclude that you are probably the most dangerous individual ever to set foot in this courtroom.